Hey folks, Attorney Sharif Silmi. I want to talk to you about the October 2024 policy update and how that might impact you and your pursuit of an EB1A application. So understand that a policy memo being issued here is intended for the adjudicators such that they are given clarity and guidance in terms of how to review and adjudicate cases. And this generally arises as a result of inconsistency in adjudication. So there have been many instances where we at Silmi Law have raised these issues to USCIS through a number of different mechanisms where there are inconsistencies in adjudication, that where one particular case has a similar level of evidence as another. It's accepted in one instance, it's not accepted in another. Now, this doesn't resolve all of the problems that we've pointed out, but it does have some degree of improvement, and it also just clarifies what policy already is. So with respect to the four issues that are being brought up, the first one is in relation to awards. So the criteria is that one has received lesser national awards. Nothing really changed here with respect to, where are the source of such awards or the level of such award in terms of its merit worthiness. However, USCIS has clarified that instances where an award is issued to a team, where the applicant is a member of a team that receives a lesser national award, that may properly be considered as evidence of the particular criteria, and it's probative of that individual's sustained national acclaim within his or her field of endeavor. So just to be clear here, what we're talking about is team awards versus individual awards. This does not mean that one who is receiving an award from his or her company would be able to use that or leverage that for the purposes of EB1A. What it means is when you have an award that's issued by an organization, that award can properly be used for the purpose of EB1A, whether or not it is a team award. So team or individual award, there's no difference. The second issue that we want to bring up with regard to the new policy memorandum is that when one is applying under EB1A and they're submitting under the exhibition criteria, that is that they have exhibited or provided artistic renderings to a particular platform, that is only considered within an art or artistic related exhibition. Now, it does provide clarity. Again, this is clarity of existing policy that where you have presented your work in an exhibition, it's not really considered under this artistic exhibition criteria. Rather, you should be considering it under other comparable evidence. So that's where you want to consider it, under other comparable evidence. Then the other issue that's being brought up is the issue of past memberships. So this has always been the case. They're just providing clarification that when one has had past membership in an organization and that membership no longer exists, then you could still leverage that for the purpose of EB1A. Now, this is very clear because the reason why membership matters from an EB1A perspective is that you have to look at what are the requirements of the membership criteria. It is that you're a member of an organization, it requires outstanding achievement of its members, and it's been reviewed by national or international experts within your particular field. So the value of your membership from an EB1A perspective is that a national or international expert has looked at your criteria, has looked at your achievements and determined that you have outstanding achievements. So whether that has happened in the past or whether it's happened presently, in both those instances, it is helpful for your case. In fact, I would argue that past membership is more valuable than present membership. So we've always considered this to be the case and always submitted it as the case. It's not changing the rule here. It's just clarifying what the rule is, which is past membership is acceptable for EB1A. The last issue that I want to talk about is the update with regard to published material. And again, this is a clarification of existing policy because of inconsistent adjudication. The criteria of publications does not mean that one's publications are significant to the field or that, they have made a real big impact in the field. That's a separate criteria altogether, that one has original contributions of major significance to the field. If we're talking about whether one has authored published material, the question is not whether this demonstrates that their work is profound or exceptional or extraordinary. The mere fact that one has published material is in of itself meeting the requirement. Now, I want to caution you because a lot of people, I think, could be misled by this change. It does not mean that if you demonstrate 3 criteria, and one of them is that you have published work, which is not really hugely significant, but nonetheless, it is published, authored material, that you're going to be approved for an EB1A. No, it's not the case, because that evidence might not be enough to establish that you meet the final merits determination. So ultimately, you could still use it and it's going to be valuable, but it's not just something that you want to rely upon to demonstrate that you meet the final merits test. So whether or not you have a published article that, doesn't have citations, for example, it's okay. It could still be used. It'll still meet the criteria, but I would caution you that it might not be sufficient to demonstrate that you meet the final merits test. And that's going to be a big deal for a lot of people because, I think if you give me enough time, I could probably figure out how to get 3 criteria for about anyone out there. But unless one has a great foundation in their field that is fundamental in terms of what kind of contributions, what kind of role that they've performed, what they've actually, introduced or provided to the pursuit of their field or their industry, then the supplemental material like having an authored publication would not necessarily move the needle a whole lot anyway. So I would just caution everybody to be careful about that. So I hope this is helpful to kind of contextualize what has happened here. I don't see this as a humongous change, but I think it does help. It does help a lot of people out there. And it does provide clarity such that we can get, more consistent adjudication. So good news. And I hope that this provides clarity, and we're always here to dig deeper and dig further into your personal case. So feel free to reach out to us, silmelaw.com. Take care, everybody. Peace out.